Okay, good afternoon. Welcome to everyone to the Privacy and HIPAA, VAWA, and FVPSA webinar. We're very excited to have you all joining us today. We have a lot of people joining this call. I want to make a couple announcements really quick before we dive into content. First, and most importantly, this webinar is going to be recorded, and with that recording comes the content in the public chat. We absolutely encourage folks to use the public chat to connect with us and to ask questions. Although if you have any privacy at all, the public chat will show your name. And so we just want to make sure that you are aware of that. And if you would rather email us to ask any questions, we will be keeping an eye on our email as well. So you can contact us at safetynet@nnedv.org if you have any questions and you would prefer to ask us by email instead of having your name show up in the recording. So again, this is the Privacy and HIPAA, VAWA, and FVPSA webinar. We have the wonderful Alicia Aiken, the director of the Confidentiality Institute, who created this content, and I'm really excited about this webinar, and I believe that everybody is. We had almost 600 people registered for this call today, so I think it'll be really great content. A couple quick announcements. Again, please use the chat if you're comfortable with your name showing up on the recording. If you registered ahead of time, you should have received the materials by email, which would have been a PDF of the presentation and a PDF of a comparison chart of HIPAA, VAWA, and FVPSA confidentiality obligations. If you did not receive any of those, please double check your junk mail and email us if you would like us to send that to you directly. We are also including closed captioning on this webinar. The link to access the closed captioning was sent specifically to those who requested it. If anybody else would like that, it is in the instructions that were included on how to access this webinar. So please feel free to click on that link and follow along that way as well. I believe those are all of my announcements, so I'm going to turn it over now to our presenter, Alicia Aiken.
Hello, everyone, and thank you so much for joining us today and for participating in the webinar. What we are going to focus on today is the difference between HIPAA and VAWA and FVPSA in the approach to privacy. So I know that HIPAA is a big issue that a lot of people feel a little overwhelmed by it, or maybe not even overwhelmed but nervous about it, right? And so they're worried about, am I following it correctly or not correctly? There is no way I could even pretend to teach you all of the ins and outs of HIPAA in the 90-minute webinar today. The goal of today's webinar is to understand the distinction between the approach to privacy under HIPAA versus the approach to privacy under VAWA and FVPSA, so that when you walk away from this webinar, you both have a good understanding and you can explain that distinction to other people. Because this is the folks who I can see who are signing up for this are people who are specialized in work with domestic and sexual violence survivors, and you are regularly interacting with VAWA and FVPSA and survivor confidentiality and privilege. And you're on this webinar today because there's something about that HIPAA comparison that isn't entirely clear. The rest of the world that does not regularly think about VAWA and FVPSA and survivor confidentiality is going to be twice as, let's just say it flat out, clueless about any distinctions between HIPAA and VAWA. So we're going to clear that up today. That's the real goal. And I jumped right into the topic because I was so excited. I forgot to give you guys a little primer on who I am. So I'm Executive Director of Confidentiality Institute. My training is as an attorney. I spent 15 years representing survivors of domestic violence and people living in poverty in a wide variety of court cases, including complex domestic violence, divorces, and custody and protective order cases. And through Confidentiality Institute, we work nationwide to empower people to protect privacy. And in fact, folks are introducing themselves on the chat room, and I can see lots and lots of names and people who I've worked with, trained with, and it's great to see you all on the call. Something I said in our last interaction was useful, and so I'm hoping that's why you came back today. Let's get right into it. So just starting with knowing which laws we're talking about, right? And the most important thing here is that these are statutes. They are federal laws, which means that the way that we understand what they mean is by looking at them. I can't emphasize that enough. I think that the great thing about living in the 21st century and about technology is that you don't have to be a lawyer with access to a law library that you understand how to use to get access to the law. You really just need to type the name of the law into the search bar in your search engine, and you will get a link to the language of the law. So whenever anyone is trying to understand what does a law mean, what does it say, you look at the law. So HIPAA, what does HIPAA actually stand for? Health Insurance Portability and Accountability Act. It's a federal law that protects privacy of healthcare information, which is collected by the healthcare industry. The second law we're going to talk about today is VAWA, Violence Against Women Act. Federal law protecting privacy of all information collected when grantees provide services to domestic violence, sexual violence, dating violence, and stalking survivors. And then the third statute is FVPSA, Family Violence Prevention and Services Act. Again, a federal law protecting the privacy of all information collected when grantees provide services to victims of family, domestic, or dating violence. For the most part today, what I'm going to do is talk about the distinction between HIPAA on one side of the line and VAWA and FVPSA together on the other side of the line. That's because the language in VAWA and FVPSA is almost exactly the same, and their purpose and intention is in fact exactly the same. So they're like twins on one side of the line, and HIPAA is on the opposite side. So let's start with a poll. A domestic violence victim shares information with her doctor and with her advocate at the shelter. Which one has stricter rules about disclosing her information? The doctor following HIPAA rules or the advocate following VAWA-FVPSA rules? Erica, do we have a poll that we can launch? All right. Then here's what I would like people to do. We're having an issue with it. Oh, good. You're chatting. You guys went right to where you're supposed to go. It's coming into the chat box. Who has the stricter rules about disclosing her information? And so lots of people are saying the advocate. Some people are saying the doctor. Some people are saying both. All right. Good. One person says both, the same level question mark. That's why we're here today, right? To take that question mark away and get an answer to that question one way or the other. So the answer on this one, let's take a look at a couple of slides, is VAWA and FVPSA. VAWA and FVPSA are relatively short when it comes to this privacy and confidentiality question, and it's relatively straightforward. And there are not a lot of exceptions. The exception is you release information if the survivor whose information it is wants you to, if they give you a written consent, if there is a law that says you must disclose the information, or if there is a court order that is a proper court order that says you must disclose the information. Those are the times when the information gets disclosed if you are a VAWA or a FVPSA grantee. If you are a health provider functioning under HIPAA, you have a whole raft of people with whom you are allowed to, expected to, and in some cases required to share protected health information. It might be other kinds of professionals who also work for the hospital. It might be the person who brought you into the hospital. It is often law enforcement. And it is almost always some kind of an insurance company representative. So when I ask the question, who has the stricter rules on sharing information between an advocate at a domestic violence shelter and a doctor, when I look at these two federal statutes right next to each other, I think the answer is very clear. The stricter rule is the domestic violence advocate at the shelter. And let me show you why. And this comes straight out of the statute. VAWA and FVPSA explicitly puts the decision about whether to share any information in the hands of the survivor. Like, that is the person who makes this decision. At no point in time is the advocate, the shelter worker, the crisis center substituting their judgment or making a decision about who should or who should not have information. It is the survivor who's making it, and the exception to that is if it's the court makes the decision or if the legislature passes a law that makes the decision. But those are pretty narrow exceptions. HIPAA, on the other hand, makes an assumption that information will be shared, and it gives medical staff some discretion to make the decision about when, whether, and how the information gets shared. Okay, so I have another poll, and this is, you don't have to, well, I'm not going to ask you who you might have heard say this, but I want to take a temperature of the group and say, how many people have heard a victim service provider say, we follow HIPAA to explain their privacy standard? So folks are coming in on the chat box, and we're getting both answers. We're getting lots of trues, I've heard that. We're getting lots of falses, I've never heard that. And that's useful because what it shows us is that we have people from all over the country on the webinar right now, and they're having different experiences in terms of what people say. And somebody notes an important distinction, which is that they have heard a victim service provider say, I follow HIPAA, and that's a victim service provider who works in a medical setting. And we're going to touch on how does that issue play out for people in the course of today's webinars. Oh, great, we've had lawyers say that they follow HIPAA standards. Well, that's I don't know what to do with those lawyers, and I will show you guys why. So you're going to walk out of this webinar, regardless of what your professional background or training is, you're going to walk out of this webinar able to show the law to other people and show them what HIPAA really actually says and means about privacy, as well as what VAWA and FVPSA really actually say about privacy. To a certain extent, I'm going to focus on HIPAA today because we spend a lot of time talking about VAWA and FVPSA. Sometimes I feel like if my children were to walk into my room at night, they might hear me reciting the language of VAWA in my sleep. And since I recognize a lot of the names on this webinar, I know that you have heard this as well, and you have access to the materials that Safety Net and Confidentiality Institute have put together. But HIPAA is the place that tends to feel murkier for people. But if there's anybody on the webinar who at some point in time thinks, you know what, I'm not clear on VAWA and FVPSA, I feel like you're giving it short shrift, I want to ask a question or I need you to cover something, just chat in and I will happily handle that. Okay, so let's just start by the differences in the professions that are covered by these two different laws, right? HIPAA is about health, and frankly, it's about health insurance. You notice the title of the statute. It is about healthcare, and VAWA and FVPSA are about victim services. So let's just talk about what's different about those two professions in the way that they work and the way that they think about their work. So thinking about medical services, there is an absolute assumption that information is going to be constantly moving between different entities. And you've noticed this if you've gone to the emergency room or you've gone to the hospital. You notice it's when you get your bills. You think that you're covered when you get one bill, but then you find out there's another bill coming in from I can't even remember the name of it right now, but the radiologist, the doctor who does the x-ray, is employed by a different office than the doctor who treated you in the ER, who is not employed by the hospital, and the hospital is going to send you a bill for whatever services the hospital gave you. My wonderful son, because he's like a giant overgrown puppy, jumped off a set of steps and broke his foot. We got 5 different bills from 5 different places, including the folks who gave him the boot that they put on his foot. There is an assumption in the medical community that there are lots of different companies who are providing necessary services together to meet your medical needs. And so information is going to get shared between those different companies all the time. And the purpose of that is for them to give you medical care. To a certain extent, that's just a result of the way that we've set up our the business of doing medicine in this country. It's not necessary that they all work for different companies, but it's just the way that our business is set up. And HIPAA was designed to facilitate the business of medicine. I do think that's an important thing to remember. HIPAA was designed to facilitate the business of medicine and ensuring that people got paid for providing medicine by insurance companies. So the other important thing about medical services, actually what I'm going to do is I'm going to jump back and forth and do medical services and victim services in terms of how we think and talk about this. So the second thing that's important is that victim services is really about, you do collaboration with other organizations at the direction of a survivor, but it's at the direction of a survivor. Generally, the idea is that somebody comes into a domestic violence shelter, they come into a rape crisis program, and that they are dealing with your organization, and they're making a choice to share with your organization. And you're going to talk to them about options and choices and possibilities, and they're going to make decisions. But no information is getting shared or needs to get shared until the survivor directs it to be shared. Which sort of takes us to the next part about who is making decisions in the medical services community versus the victim services community. So medical services is about doctors, right, collecting information from the patients, whether it's the history of what happened to you or it's a physical examination, and then applying their particular expertise and knowledge to your information so that they can make a decision about what's the best thing for you. Right? It is rare that a doctor will come into you and say, you have 4 different options here, and here's a complete description of each one, and I don't really care which one you pick. But that's just not the way that doctors think. They tend to come in and say to you, even really good, really collaborative doctors, there's 2 choices here, and this is the one I think is best, but it's your choice, right? And if you trust your doctor, you go with the choice that the doctor made. That's different from the model of providing victim services, which is that victims are the experts in their own lives and that they have to bear the risk of the decisions that they make, and so they're going to choose them. And you as a victim services provider are assisting to make more information available and to expand their options, but ultimately it's the survivor who has the expertise to make a decision about what to do in his or her life. So that's just a very different model. And again, I'm not saying that there's anything wrong with either model. I come from a long line of doctors who were, aggrieved when I went to become a lawyer instead. But I have an enormous respect for the work, but it's just a different approach and philosophy about who's making decisions and what is being done with information. And I think, in the doctor world, like medical providers are concerned that if they lack some piece of information that another medical provider possessed, that they might make the wrong judgment call and that might result in harm to you. For a victim services provider, the concern is that if information gets disclosed without the survivor knowing about it or approving it or preparing for the risks of it, that survivor could be located, identified, outed, and that there would be some harm to the survivor. So both communities are thinking about how do they manage information to reduce or prevent harm from happening, as well as thinking about how do I use information to create good. The goal of the HIPAA privacy rule, and this is straight out of the Office of Civil Rights Privacy in HIPAA website, and I recommend the site is at the bottom of the slide that you are looking at now and that you also have in the handout. I recommend anytime you have a question about HIPAA and privacy, go to this site. The materials are actually extraordinarily well done and easy to use. And to the extent that they're confusing, it's not the OCR's fault. It's the people who drafted HIPAA's fault. But that's a different topic. But they are quite explicit that the purpose of the HIPAA privacy rule is to assure that information is protected while allowing the flow of health information. The goal is to allow the flow of health information, but make sure it maintains a relative amount of safety while it is flowing. Okay? And there are actually 2 purposes behind the HIPAA philosophy. One is to provide individual high-quality health care, and the second is to protect the public. So think about that. The privacy rule under HIPAA has 2 masters, if you will. One master is your healthcare as an individual, so your information should get used appropriately to provide you healthcare, and your information should get used appropriately to create public health and well-being. So that's not about you, that's about the public. And the definition of public and health and well-being is very broad, and we will get to that. So for those of you who like visuals rather than words, if you think about what are the purposes behind HIPAA, it's quality health care. And for some reason, every time I see this picture on the top, I can hear the music from ER in my head. So they're coming to get you, and they're going to give you some quality health care. And they're also thinking about everybody in your community. And your community might be your whole country, or your region, or your city, or your state. But those two things are going on at the exact same time whenever a medical professional is making a decision about whether or not to share your information. So the OCR also talks about the fact that HIPAA strikes a balance that permits important uses of information, and that it is designed to be flexible and comprehensive. So note that word flexible. Again, these are quotes. These are not my words. And for those of you who have been working under VAWA and FVPSA and those privacy rules for any amount of time, you probably are not thinking, oh yeah, VAWA is flexible. Right? It's not. It's a very different kind of statute. HIPAA is intended on the privacy question to be flexible. So here's an example of how it is flexible. That what HIPAA says is that a covered entity or a business associate may not use or disclose protected health information except, and then it proceeds to give you 1, 2, 3, 4, 5, 6, 7, 8 categories of exceptions to their rule that you should never disclose information. Right? That's a big hole. That is a pretty big exception, especially when the final exception is public policy exceptions, which then results in another at least half a dozen kinds of exceptions that you might not have thought of off the top of your head as being public policy exceptions. And one thing I want to note, you got an email before. If you didn't have an opportunity to open it, that chart that is in the materials that were sent to you that compares right next to each other provisions in HIPAA and provisions in VAWA and FVPSA gives some more detail on some of these terms of art like covered entity. And it also gives you the cites to the regulations and to the statutes. And again, you don't need any legal background. You don't need any legal training. You are here in the United States of America, and the whole point of our system is that laws are supposed to be accessible and available to everyone. And if you've got access to the Internet, then you can type any of those regulations or statutes into a search engine and it will pull it up. Most likely you'll get it from Cornell Law School's Legal Information Institute, and I just want to give a plug for them because they do a phenomenal job of making the law accessible to everybody who's got access to the Internet. If at any point in time you have questions, please let me know. And if it's a question that I know I'm going to answer, I may hold it until I get there. But if it wasn't on my agenda, then I'll know that I need to fit it in. Okay, let's shift our analysis to looking at VAWA and FVPSA privacy. And this, again, is language that comes straight out of the law, that the goal of VAWA and FVPSA privacy is to ensure the safety of victims, and grantees and subgrantees shall protect confidentiality and privacy. And actually, it's important to note that the goal of VAWA FVPSA privacy is actually bigger than just the individual victim. That its goal is to ensure the safety of victims and their families, and to ensure protect the privacy as well as the confidentiality of victims and their families. So I apologize, I dropped off the and their families, and I should not have done that because that's an important point, that we are thinking not just about the victim who calls us, but the people who are closest to them, who they care most about, also ensuring are safe, because we know that so often people who are victimized by family members or by partners don't reach out for help because they're not so much afraid that they'll get hurt, but they're afraid that someone else who they care about will get hurt. And VAWA and FVPSA recognizes that in their privacy language. So for those of you who like visuals, the point of VAWA and FVPSA is to ensure safety and to prevent disclosures that are going to violate your privacy. Right? There are some disclosures that may not result in you being physically assaulted, but will certainly result in you feeling like you are unsafe because people are talking about you, judging you, shaming you, discriminating against you, using information that has become public that you did not want public to label you, and then impair your ability to sort of function freely and spend your life as something other than a person who has been victimized. Okay. I'm just going to jump back a little bit because I want us to do a quick comparison. I should have put the slide in a second time. Okay. Here's what HIPAA privacy is about. We're going to give you health care, and we're going to protect the whole community. VAWA FVPSA, we're worried about your safety, and we're worried about you not being shamed and outed. Okay? Very different goals. So this is the grand total of the exceptions on VAWA and FVPSA on privacy. The grantees and subgrantees shall not disclose personally identifying information except when there is a written consent, there is a requirement in a statute, there is a lawful requirement from a court. That is a way shorter list than the HIPAA exceptions. There is one other exception. I lied before when I said that the previous slide was the sum total of the exceptions. There is an exception for courts, prosecutors, and police that receive VAWA funds, which quite a few of them do around the country. Information that is generated by the court, the prosecutor, or the law enforcement agency, and where that information is used for court, prosecution, or law enforcement purposes within the legal system, the VAWA privacy rules do not apply to that. Now, what do I mean by that? That does not mean that if you are working in a domestic violence shelter and the person who asks you for information is a prosecutor or a law enforcement officer, you are still bound by VAWA not to disclose that information unless the victim consents. So I don't want us to get confused and think, oh, but it's a law enforcement officer who's asking, so therefore I'm supposed to give it to them because VAWA has this law enforcement exception. What the law enforcement exception means is that if you are a police department and you receive VAWA funding, you are allowed to disclose information as you need to do and are required to do to investigate crime, to make arrests, and to bring prosecutions in court. And that's just because the role of law enforcement is frankly to be transparent, somewhat transparent with the community and also with defendants with information. So if anybody has any questions, sometimes people can get tripped up on this court, prosecutors, and police exception. If anybody does have any questions, please ask them. You can always email us later. In fact, one of the things I'm going to do is put when you email safetynet@nnedv.org with a question, SafetyNet and Confidentiality Institute partner together very closely. So you will often also get Confidentiality Institute brought in on that conversation. But I also wanted to give you the Confidentiality Institute email in case you ever want to email me directly or CC me on an email to SafetyNet. And now I'm realizing it's not a good idea for the presenter to try to type a complex email address and present at the same time. Okay. Erica, can you help me out? For some reason it's not coming up in my chat box that I actually posted anything. So if you can post my email address, that would be great. Thank you. Okay, so let's do a sort of more specific comparison of how the HIPAA and VAWA FVPSA privacy laws are different. What we've talked about so far is overall philosophy and assumption of the professions and the laws, but I want to talk about some very specific ways in which they are very different from each other. And I call this differences I see. And part of the reason I say that is because the expertise of Confidentiality Institute is in VAWA and FVPSA. This is something we work with regularly. I'm not holding myself out as a specific expert in HIPAA. And HIPAA is an enormously complex law to implement because it has a lot of regulations and a lot of exceptions and a lot of what I call if this but then that's. And so what I have done is spent quite a bit of time over the last year studying it, analyzing it, and thinking about it. And in that time, I have sort of come up with these 10 differences that I see. But if you dig into this statute, or in your experience, you might see others. And if you do, please share them, because it helps all of us to grow. And I was just talking to someone today and saying, every time I look at HIPAA, I see some new thing that I didn't quite see before. And I think a lot of people have that experience. So the first difference I've already mentioned, which is that HIPAA assumes that information will flow routinely. And VAWA assumes that information will not flow. Pretty straightforward. The second difference that I see is just in the fact that HIPAA and VAWA apply to different kinds of information. The category of what's protected is just a little bit different between the two. And so HIPAA applies to protected health information, and VAWA has a slightly broader definition, which is that it applies to all personally identifying information. VAWA and FVPSA both talk about all personally identifying information, and VAWA talks about individual information being protected. Now, these two categories have a lot of overlap, and there's a lot that's similar in them, but there are some ways in which they are different from each other, and so it can be important to think about what does that mean if somebody's saying to you, I want you to do this because it would be okay under HIPAA. If you're under VAWA, the first thing you would say is, well, we're not under HIPAA, we're under VAWA. And then you would say, and how is the category of information protected under VAWA? If you are feeling uncertain about how the VAWA defines personally identifying information, then you want to take a look at the statutes and the handouts that we have available at tools.nnedv.org. Okay, so the third difference that I see is that HIPAA is balancing public health and personal privacy, and VAWA and FVPSA are centering individual safety and personal control. Okay, difference number 4, and this is a biggie, and the nature of the changing modern world makes this a even bigger biggie, which my 6th grade English teacher would probably fall over in a dead faint if she heard me say bigger biggie. But the HIPAA has a specific category called business associates. And do me a favor, everybody, raise your hand if you have heard this term business associates before. All right. I feel like I'm not using the raise your hand correctly. Excuse me. Okay, so HIPAA has this category called business associates, which is if you're going to hire somebody to do something that is not medical. So the thing that they're doing for you is, for instance, managing your electronic health records or your patient information databases. Those people are not participating in your health care. So it's not the same as the primary doctor sharing information with the radiologist. This is the primary doctor and the hospital sharing information with a tech company that is going to maintain a database, and then that database tech company is going to also put the information on a database hosting company. Those folks are business associates, and HIPAA specifically says you can have business associates. You have to enter into very specific agreements with those business associates, and they have to follow the HIPAA rules of protecting privacy. But you are allowed to do it, and in fact it's expected to do it in some ways. The whole industry really expects that you are going to be farming out pieces of your work to business associates. VAWA does not have any concept like business associates in it. There is absolutely nothing in VAWA that says you are allowed to give personally identifying information of survivors to someone else who is not trained in the domestic violence and sexual assault and stalking and trafficking issues that you work on, who is not a member of your organization. there's nothing in VAWA that says you can give those people private information without having to get consent from the survivor. So it's a very important distinction because so many programs are being pushed into using cloud-based data providers. And cloud-based data providers, when you use them, you are, unless you are following encryption, proper encryption practices, you are giving personally identifying survivor information to those programs. So that can be a real issue when you're trying to think about what can you do or what can't you do in terms of how you set up the business of providing victim services. Okay. Okay. Difference number 5. HIPAA allows sharing a limited data set of protected health information with researchers. So again, because HIPAA is concerned with public policy and public health, it specifically plans for the idea that there will be research being done on the information of patients, and that information will be identifiable so that the medical researchers can tell the difference between one patient and another patient. And that's sort of normal and reasonable and okay and not a violation of HIPAA privacy rules. VAWA and FVPSA do not have any exception for researchers. There is nothing in there that says you are allowed to give personally identifying survivor information to researchers so that they can study what's happening, how your services are working, how people are doing after they use your services, all of these things which may be useful things to research and important things to research, but in the process of researching them, we do not have the authority under VAWA to share personally identifying information. And so one of the reasons it's so important for everybody on this webinar to understand these differences is because when you get approached by people who are used to being business associates for hospitals or approached by researchers, they may be walking in with an expectation that you follow HIPAA rules or that your rules are like HIPAA. And you're going to want to undertake the work and the time to explain to them that you actually function under a different set of rules and that it's not the same. And it's not that you're being a jerk, because I think sometimes that's what I see happen when people reach out for technical assistance is that the researcher or the provider think that you're just being unreasonably difficult. And really what you're saying is, no, we just have a different model of how we do our work and how we engage with the rest of the world because we have a different priority for a very specific group of people who are undergoing a very specific kind of trauma and how we're going to respond to them. All right, differences I see number 6. HIPAA gives professionals some discretion to decide to disclose personal information. And it means that they don't even have to tell the patient all the time. Sometimes they do. But basically what HIPAA assumes, and again, having grown up around many doctors, that HIPAA makes an assumption that the medical professionals have good judgment and know what should happen and what should not happen. And so HIPAA has a lot of moments in there where it will say that the medical professional, and I think in some ways they're assuming the doctor gets to make a decision about what can or cannot be disclosed in certain circumstances. And in the course of this webinar, I'm not going to go through all the details of those exceptions. If somebody is in a situation where they are actually trying to figure out are they allowed to make a decision to share information, and you are a medical professional who is only following HIPAA rules, then you're going to want to go and look at the actual HIPAA rules. You can look at that comparison chart that we've passed out today to figure out if this is one of those moments when you as a medical professional are allowed to make the decision to share information. But if you are functioning under VAWA or FVPSA and providing victim services, then you don't ever get to make that decision. You don't get the discretion to decide to disclose information. If you are forced to disclose information, whether it's by a statutory requirement or a court order requirement, then VAWA and FVPSA both require you to make reasonable attempts to notify the survivor whose privacy is being violated and to assist them in protecting their privacy and safety in response to that. So that's a really big difference to me. And again, I think that's a difference that boils down for me to philosophy of the different laws because they apply to different professions. So it's important to understand that HIPAA does in fact give discretion to the professionals. So again, you may be talking to people who are used to talking to doctors who, if they convince the doctor, right, if they give a compelling enough argument, the doctor may say, you know what, based on what you've told me, I'm going to make a decision that this information should be shared. Whereas if they were talking to a victim services provider, there is no amount of information that they can give him that be persuasive or compelling enough to get you to make the decision to share information. The only thing they can do to compel you is show you a law that requires it or show you a court order. All right, differences that I see, number 7. HIPAA allows for sharing some information with law enforcement at the doctor's discretion. And that does not require a specific statute or a court order. Now, I don't want to be overbroad here. I'm not suggesting that any time a law enforcement officer asks for information, a doctor could make any decision he or she wants about sharing that information. But there are lots of places in HIPAA where it allows the doctor to share information. And one of them is really striking. So I actually made a list, and this is all based on what we call 45 CFR 164.512, and that's the regulation, and it's actually in the comparison chart that we sent out to you. And it is a regulation that says that these are the times when you can disclose information to law enforcement. So if law enforcement comes to a medical provider and says, we're trying to find a material witness, a fugitive, or a missing person, then the doctor is allowed to tell them the person's name, address, date of birth, social security number, blood type, injury, date of treatment, date of death, and physical description. That's a really identifying list of information, and we should be very attuned to those two words, material witness and missing person, as well as the term fugitive. Right? So we know that abusers will file missing person reports to try to find their victims. And we know that sometimes there is a disagreement between a victim and a prosecutor's office about whether or not to go forward on a criminal case, and that some prosecutors will choose to treat the victim as a material witness who needs to be taken into custody to require them to testify. So if the law enforcement goes to the hospital looking for that person, the federal privacy law tells the doctor, yep, you can tell the officer. You can't tell the officer, what the person's medical diagnosis is or what future surgery they're going to have, but you can absolutely tell law enforcement where they are. Now, under VAWA, it's completely different, right? That list of things that I just reeled off that that doctors are allowed to tell law enforcement officers is almost exactly the list of things that you're not allowed to disclose under VAWA. That VAWA in general prohibits the disclosure of identifying information, including name, address, date of birth, social security number, and any information which in combination might serve to identify the location of a survivor of domestic or sexual stalking or dating violence. that's just one example of the kinds of law enforcement disclosures that can be made by doctors. Another example is if there is a subpoena to a doctor or to a healthcare provider. They are allowed to answer that subpoena if there are, quote, reasonable assurances that the patient has been notified and the patient fails to object. So in other words, the onus is on the patient to know about the subpoena and to object to the subpoena and to tell the doctor that they've objected to the subpoena, as well as telling the court or the person who issued the subpoena. That's very different from VAWA and FVPSA, where you are not disclosing any information unless you get an affirmative written consent from the victim that you have worked with, or you get an affirmative and lawful court order. And that's a whole other topic about whether a subpoena is or is not a court order and how do subpoenas get challenged. If anybody ever has questions about subpoenas in your victim services organization, you can reach out to the American Bar Association Subpoena Defense Project, and that's a joint project of Confidentiality Institute and the American Bar Association to defend victim service providers against subpoenas for victim information. So I think that you are picking up what I'm laying down, which is that when it comes to law enforcement, that the approach of HIPAA, and I think this is about the public policy philosophy, that law enforcement is there to promote community safety and well-being, and that HIPAA is concerned with the public policy of public safety and well-being, so that law enforcement expects medical providers to be in partnership with them, and that HIPAA expects medical providers to be in partnership with law enforcement. There is nothing wrong with that. That's just the law that we have. The victim service provider rules under VAWA and FVPSA are different. I'm not suggesting that you should be enemies of law enforcement, but the victim service provider is in partnership with the survivor. And the level of partnership and interaction with law enforcement is going to be determined more by the wishes and requests of the survivor than by the wishes and requests of law enforcement. So again, it's not that one is right or one is wrong, it's that they're distinct from each other. And I'm just going to let everyone know that there is an odd technical difficulty going on, that despite the fact that I encouraged you to really, really chat in and tell me when I'm funny and interesting, my chat box has just completely frozen. So you're not seeing what I'm sending out, and I'm not seeing what you're sending in. The good news is that because this is SafetyNet, we have multiple technological systems for communicating with each other, and Erica Olson has an alternative system for funneling me your questions. So I will still get your questions, and then responses from me will come through her. The question of, is a material witness a legal designation, or it's at the discretion of the investigator? It's sort of both. So it's basically, there's typically a legal definition in each state of what makes someone a material witness. And then each state has a different procedure for how does that person get identified as such, but it's usually something that the prosecutor has to participate in. Prosecutor and law enforcement do it together. And they say, we're going to designate this person a material witness. And then often the reason it comes up is because they go to the court and they ask the judge for an arrest order to go out and find and take into custody the material witness to ensure that that witness will be present to testify. So I just got an interesting question about HIPAA protecting a medical provider from having to testify about a SANE exam. And that's an interesting question. So HIPAA, so I think that's probably right, and I'm going to say probably because I think in HIPAA it all comes down to the devil in the details of the particular situation. But basically, if the issue is that there has been a subpoena to testify in court, and the hospital has a reasonable assurance that the victim, or the patient in this case, has received notice of the subpoena, and the victim has failed to object to the subpoena, then HIPAA would allow you to testify. However, that's a lot of ifs, right? And you as a provider can take a stronger stance in HIPAA. So HIPAA is a floor. I think that's a really important thing that I have not said yet. So thank you very much, Logan, for asking that question. HIPAA is a floor, meaning that this is the point below which privacy shall not go. You as providers, medical providers, can give more privacy. They can say, we take a policy position, or our state law requires us, or our ethics require us to take a more protective position than HIPAA. So I would say that a really good medical provider, especially with SANE exams that gets subpoenaed, would take a position that says, we will not come in on this unless we know that the victim has been notified for sure, and that we've been able to communicate with the victim about whether this person objects or does not object. And we may go into court and we might fight it, we might not fight it. SANE exams are a tricky one because SANE exams are in fact, the purpose of them, and to a large extent, is the preservation of evidence. So then if there's a court case about the event, and this is evidence of the event, I think most judges are going to order that it get disclosed. But I also think you never know what a judge will or won't do. I'm sorry, that I felt like a very long-winded answer on my part. But the bottom line is that HIPAA, you couldn't go into court and say, Your Honor, we are prohibited from releasing this information because we are covered by HIPAA. I don't think that would work so long as the patient had actually gotten notice of the subpoena. Okay, so let's keep going forward. I just heard that the chat has been super busy, which, I'm like, oh, I want to see what you're saying. But the good news is that Erica and I have a long and successful partnership in fielding topics together. So she's responding to you and also transferring my answers where appropriate. All right, so just last thing I'm going to say about the law enforcement issue is that VAWA and FVPSA does not allow disclosure of information to law enforcement unless there is consent. There is a court mandate, which I always say is a lawful court order. And I've spent 15 years as a trial lawyer in 3 different states, and I saw plenty of unlawful court orders and appealed them and won. But if you don't appeal and you say, well, it's signed by a judge, so it must be a lawful court order, that's not a fair assumption. Sometimes it's unlawful and it needs to be appealed. Or you must have a statutory mandate, which is a law that says you must do something, not a law that says you may do something, and not a regulation. And that's a distinction that comes up sometimes. So for instance, some of what I'm talking about in HIPAA, I've been referring you to the CFR, which is the Code of Federal Regulations. Very basic, quick, really quick civil procedure here. A statute is passed by a legislator made up of people that we elected. And if we disagree with what they do, we can elect someone different in the future. A regulation is a rule made up by bureaucrats. I'm trying to think of a nicer, less weighted word, but it is a rule made up by bureaucrats intended to implement a statutory law. If there is a rule, a regulation that violates a statutory law, the statutory law always wins if there's a disagreement between those two. All right, differences I see number 8. HIPAA allows some disclosures based on oral or informal consent or failure to object. So when we were talking about subpoenas just now, HIPAA explicitly says if the patient fails to object to a subpoena, then the hospital is allowed to answer it. There are lots of places where HIPAA says if you are in the room and there's another person in the room with you and you brought the person in the room and that person asks a question, the doctor can answer it. Unless you open your mouth and say, wait, stop, doc, don't answer that question. I don't want you to. And I can understand the reasons for that, right? Like often when we go in to see a medical provider, we go into the hospital, we bring people with us and we make choices about who are the people we want with us and who are the people, or actually, given the work that we all do, sometimes we didn't get to make the choice about who we wanted with us. It may be that our abuser or our assailant said, I'm coming, and we didn't feel like we had a choice. And the doctor may or may not know that. But HIPAA says if you've involved someone in your care by bringing them in with you, then while you're in the room, the doctor's allowed to talk in front of them. The doctor's allowed to answer their questions. The doctor's allowed to make judgments. If you are incapacitated and you can't say to the doctor, yes, talk to the person, no, don't talk to the person, the doctor gets to make judgments about that. And there's actually a really great handout on that, also on the Office of Civil Rights website. And I will find the site for that flyer, which is available online, and send that out, because it does a really nice job of explaining how much discretion medical providers have to talk to other people, family and friends, about what's going on with you. And essentially what the doctors are doing is they are making a moment-by-moment decision. What in this moment in time is the right thing to tell this person? How much and how little do I think that I should or should not tell them? But again, the key there is the doctor is making the decision, or the medical provider, the nurse is making the decision. Now, it's completely different under VAWA and FVPSA. VAWA and FVPSA requires an affirmative written consent before information gets released. So they don't have the ability under VAWA and FVPSA. There's nothing in there that says that you can get an oral consent. There's nothing in there that says informal consent. And there's nothing in there that says, oh, you can do it as long as the victim fails to object. Those concepts just do not exist under VAWA. Okay, differences that I see, number 9. HIPAA allows for the disclosure of protected health information for audit and government oversight. So there's a long list of situations and reasons, fraud investigations, regular oversight, regular reporting, where medical providers are allowed, and in some cases even required, to turn over identifying protected health information to outsiders to facilitate audit and oversight and reporting and evaluation. VAWA and FVPSA actually explicitly says that you're forbidden from disclosing personally identifying information to comply with government grants. So that's a pretty big difference. And again, if we are living in a world where people think HIPAA is the gold standard, which I think is pretty clear from this webinar, I don't think that, but I definitely think we're living in a world where many people think that HIPAA is the gold standard of privacy. If that's the world that we're living in, when someone comes to you and demands information, if they're used to getting it from hospitals or doctors who they know are covered by HIPAA, and no one has educated them that VAWA and FVPSA is actually stronger, then they're going to give you a hard time. They're going to think that you are being difficult. And so educating them about how VAWA and FVPSA are in fact quite different and much closer to a gold standard than anything that HIPAA could ever hope for is really important. Differences I see, number 10, and by the way, number 10 is the last one. I know that you really couldn't think of a more invigorating and exciting way to spend 90 minutes than doing a detailed pick-apart of HIPAA, and I appreciate that everyone is still with us, and I hope that you're getting a lot of useful information out of this. So differences number 10, HIPAA, you can refuse some services if a patient declines to disclose protected health information. So in some circumstances, if the medical provider asks the patient for a release of information to disclose personal health information outside of, say, the hospital or the doctor's office, and the patient says, I'm not comfortable doing that, I'm not going to do it, in some cases the doctor is allowed to say, that's fine, I respect your right, I'm not going to give you any medical services. I'm allowed to say no, and I'm allowed to turn you away, and I'm allowed to send you elsewhere. That is a big distinction from VAWA and FVPSA, where you are never allowed to make a releasing personally identifying information a condition of services. So you can't, if somebody comes to a rape crisis center and asks for help, you can't say to them, sure, our work is funded by this foundation, and we just have everybody sign a release form. to share information about the services we give you with that foundation. And we're going to share your personally identifying information. If the victim says, no, I won't sign that, if that Rape Crisis Center is also taking VAWA money, then they have to say to the person, okay, I respect that decision. That's totally fine. How can we help you? You're not allowed to turn people away because they made a decision to be protective of their privacy. All right, so let's give this a little bit of a practical application, thinking about the environment where we have both an advocate and medical providers in the same room together. So let's just say that a sexual assault victim comes into the emergency room, and she comes in with her sister. And the victim meets with an advocate from a local rape crisis center who has been dispatched to the emergency room, and the victim and the advocate have a conversation with each other. And then the victim is also being treated by a doctor and a nurse team. And let's not think of this as a sane nurse right now. This is not a forensic exam. This is just they're receiving emergency medical services from a doctor and a nurse. So the victim becomes distraught. And when that happens, her sister is actually out of the room making a phone call. And the doctor administers a sedative, and the victim goes to sleep. And her sister comes back into the room and is understandably upset, right, that suddenly her sister is not conscious anymore. And so she says, why is she asleep, and do we know who did this to her? And the people in the room are the doctor, the nurse, and the sexual assault advocate are all there and have to make a decision. What do they say back to the sister? Are they allowed to answer her question? How are they allowed to answer it? What should happen next? And when you think about what we've just gone through with all the rules for VAWA versus HIPAA, the HIPAA rule is going to apply to the doctor and the nurse because they are healthcare providers. So the HIPAA rule applies to them. And if the victim actually brought her sister in with her and showed the doctor and nurse that her sister was participating in her care, then I think it would be totally appropriate under HIPAA for either the doctor or the nurse to say, she became distraught, we gave her a sedative, she's sleeping, we don't have any concerns about her stability or brain function, we expect that the sedative will wear off in 4 hours. I think under HIPAA, the way that I read all the language in HIPAA about people who are involved in your care and doctors and nurses getting to make judgment calls about what's in your best interest, that would be allowable under HIPAA for them to say all those things. Now the question of do we know who did this to her, I think is a much grayer question. If for some reason while the medical history was being taken, they got that information, I would think that the who did this to her is not related to the medical care, which is what the doctor and the nurse is supposed to be thinking about right now. So I would say I think that's outside of bounds, but there might be medical providers who would disagree with me and think, nope, I'm absolutely allowed to share that information if I think it's necessary or appropriate with the person who the patient has involved in their care. And that's the key term. The patient has involved this person in her care. Now the flip side is the advocate is not allowed to share information that she's received from the victim, because without the victim saying, I want you to share that information for me, and without them having an ability to discuss the pros and the cons. Because who knows who did this to her, right? What if while the sister was out of the room, the reason she became distraught was because she disclosed that the person who did this to her is her sister's husband? And she has to figure out what to do about that, whether to prosecute, whether to tell her sister about it and how to handle it. And then the sister comes back in the room and says, do we know who did this to her? Because she cares and she's worried. She has good reasons for asking the question. But whether or not she gets that information is up to the person who was victimized, not up to the advocate. And if she's incapacitated right now, so she cannot have a discussion about whether she wants to share that information and she cannot sign a release form to share that information, then the advocate is going to not share that information and is going to do appropriate discussions with the sister who is experiencing some trauma, right, as a tertiary victim because someone she cares about has been assaulted. So it doesn't mean don't talk to the sister. I always emphasize this idea of protecting somebody's privacy and their personally identifying information doesn't mean that you are prohibited from speaking to other people. It means when you are speaking to other people, you are prohibited from disclosing personally identifying personal information about them. Okay. Let's see. So I have a question. Did I say that when a federal rule violates statutory law, the statutory law trumps the federal rule? So I did say that. What I said is that if there's a regulation that violates, so if there's a federal regulation that violates a federal law, the federal law wins because the laws are made by the legislature and the regulations are made by bureaucrats. If there is a state regulation that violates a state law, the state law is going to win. If there's a federal regulation that violates a state law, it gets much more complicated and much more complicated to figure out which one wins. But if you just think of it as a hierarchy, that a state law is higher in the hierarchy than a state regulation, and a federal law is higher in the hierarchy than a federal regulation. But because we have a federalist system in our country, how state laws and federal laws relate to each other is always subject to discussion and debate. So it's going to be very dependent on the specific one. And I would like, if we could, to take that question about the federal rules for civil procedure out of this conversation today and have a separate conversation about it. And probably the best way to do that is to email safetynet@nnedv.org, and we can have a discussion about that because it's an interesting question and it's an important one to discuss, but it's separate from today's topic. Let's see. I do have a question about a SANE nurse and VAWA. A SANE nurse falls under VAWA if they work for a VAWA grant-funded agency. That is exactly right. So the VAWA rules apply to agencies that receive VAWA funding. And I want to be very clear about one important thing. We are not discussing at all today state-based privilege or confidentiality rules. So many of the people on the phone may be covered by a state-based confidentiality or privilege law that is stronger than VAWA or FVPSA or HIPAA. And so there's nothing I'm saying today that is like, look, this is what you have today is going to tell you exactly what your requirements are. I can't do that for you because you may be controlled by some local state law, and that state law may be both stronger or weaker or just different. So it's important to know that. But the VAWA rules apply to programs that receive VAWA money. So if there are two domestic violence shelters on the same street and one gets VAWA money and the other one does not, the VAWA rules, the one that gets the VAWA money is required to follow those rules. The one that doesn't get the VAWA money is not required to follow them, although would be smart to follow them so that you can be eligible to get VAWA money later on and you don't have to change all your practices to make it possible to get the money. Let's get to the question of what do you do if you have kind of a hybrid organization, because some of the questions that are coming up are related to that. And I'm just going to ask people to think about this question and answer it for yourself since my chat box is frozen. So this question, true or false, my organization can choose whether to follow HIPAA or VAWA FVPSA privacy. I kind of gave away the game on that one because I started talking about that topic already, about whether or not you can choose or must follow. So I'm going to jump ahead. Right. If you are a covered entity under HIPAA, and that is a healthcare provider, that is a, well, I'm sorry, the covered entities under HIPAA are health insurance providers, healthcare clearinghouses, which most direct providers are not healthcare clearinghouses, or healthcare providers who bill healthcare providers who transmit information electronically. If your organization has a question about whether or not you're covered by HIPAA, you shouldn't try to answer that question by listening to this webinar. You should answer that question by having a specific conversation with somebody, with an attorney in your jurisdiction who can help you to look at that question, because it can be, there's both huge numbers of people who are covered by HIPAA, but sometimes there's exceptions, and it definitely can come up if you are in a multidisciplinary victim services program and you are providing, for instance, mental health counseling, but you are not submitting any information electronically. You may actually not be covered by HIPAA, and you may be covered by it. So that's where it can get a little bit tricky. The reason why the rule is healthcare providers who submit information electronically has to do with basically, when is the federal government allowed to make laws that apply to local programs, local small doctor's offices? Why is a doctor's office on Main Street in Vermont, why is the federal government allowed to make a rule that affects them? Well, because if they submit information electronically, then they're essentially crossing state lines, and then therefore the federal government is allowed to worry about things that cross state lines. That's really what underlies all of this, is and I'm getting a little bit too law professory right now, so I'm going to back off of that. But if you're uncertain whether HIPAA applies to you, reach out, ask for help, ask for technical assistance, get local counsel to help you look at that question. Because it can be just you fall on one side of the line or you fall on the other side of the line. I just talked a minute ago about VAWA and FVPSA. If you are a grantee or a sub-grantee, and there are lots of programs around the country that are sub-grantees of VAWA, but the money comes from some state authority. So for instance, in Illinois, the Illinois Criminal Justice Authority passes out money, but the money that they are passing out comes from VAWA. So all the people who get that money are required to follow the VAWA rules. So if your organization is uncertain whether you get VAWA, you need to make sure you get an answer to that question. And if none of your grant reports have the word VAWA on them, that doesn't necessarily mean you don't get VAWA. You want to check who's giving your money, where did their money come from. If you are covered by both, and so it is entirely possible that there are folks out there who have a unit that is covered by VAWA because you get VAWA funding, and is covered by HIPAA because you are providing mental health counseling and submitting billing electronically for that mental health counseling. If you are covered by both, you follow both, and when they're different from each other, you follow the most protective rule. Basically the message of the last 75 minutes has been that generally the most protective rule is going to be VAWA or FVPSA, not HIPAA. So if you are covered by both, because the intention of both is to protect privacy, if you're covered by both, then you're going to be looking to follow the most protective one so you can give the best protection for people's privacy. Under HIPAA, there's a concept called the hybrid organization. So if you have an organization that does different things, for instance, if you have a victim services program that also has a mental health counseling unit, and that mental health counseling unit is covered by HIPAA, and you want to know, does your whole victim services program have to follow the HIPAA rules? HIPAA has an idea called the hybrid entity. And basically what you do is you formally identify as a hybrid entity, meaning you do different things, and then the HIPAA rules apply to the healthcare unit, which in my example would be the unit providing mental health counseling, and information gets kept within that healthcare unit, and sharing any information outside of that healthcare unit, even within the same organization, but outside of the healthcare unit, counts. It's just like disclosing it to a third party. So you have to follow all the HIPAA rules before you disclose it to a third party. And I think, frankly, I think for a lot of programs, taking advantage of this hybrid organization designation, if you are both VAWA and HIPAA covered, I think this could make a lot of sense. I think you should take a serious look at this option because it it makes an enormous amount of sense under the philosophy of VAWA to just continue being as protective as you can. And then you don't get into a question about whether or not your shelter somehow has to follow HIPAA rules because you have a mental health counseling program in a completely different location. So I think this hybrid organization option, it's unclear to me how often organizations take advantage of this, and I think it's an important option to be aware of and to seriously consider using. If you are a multi-service agency, and let's just say you're not covered by HIPAA, you don't have any health care that you're doing, but for instance you are a YWCA and you get VAWA money, how do you manage information? The best practice for that is to identify your VAWA-funded victim services unit, or if you have a shelter, your FVPSA-funded victim services unit. Identify that unit. Keep information inside that unit, follow VAWA rules about written consent to disclose within that unit, and then sharing any information outside of that unit counts like it's disclosing it to a third party. So it is the same thing, disclosing information to another department. If you're the YWCA and you have a VAWA-funded shelter, if you are considering sharing information with the swimming program, you have to get an affirmative written consent from the survivor, and it needs to be meeting their needs and so that they can do what they need to do to cope with the experience that they've had. So I suspect that some of you may be looking at your computer screen exactly like this guy, feeling more confused and frustrated and like you're locked in a small gray room. And I don't want you to feel like that. To a certain extent, that is the unavoidable collateral damage of talking about HIPAA. And what I really want to do is we want to provide clarity. We want to provide answers. And so that's why we've created the chart that we sent to you. And why we're available to give help. So the Office of Violence Against Women funds Safety Net and Confidentiality Institute to provide technical assistance to its grantees on questions around privacy and confidentiality and technology. So you might have a question where those things interact and they might not interact in your question. Either of those is absolutely fine. And you can send an email to both Safety Net and to me at Confidentiality Institute, and I think we do a pretty good job of being really responsive. I will say that sending it to Safety Net is your best chance of getting the fastest response because there's the most people are watching that email address and making sure that it gets responded to. I think that it is important that programs get advice of local counsel, that you work with an attorney who can look at these laws, especially if you think you're covered by HIPAA. It has a whole lot of complex exceptions to it, and I think it's important to communicate with a lawyer so that you know why you're doing what you're doing. And another thing that Confidentiality Institute will often do is give technical assistance to lawyers who are representing programs because the lawyers are local attorneys and they're very good attorneys, but they just don't have a specialty in the implications of VAWA and FVPSA and survivor privilege and confidentiality. And Confidentiality Institute is able to provide technical assistance to those lawyers so that they can give you the best possible service. And then finally, take advantage of online tools. The tools.nnedv.org has lots of materials explaining VAWA and FVPSA, how to apply them, how to use them practically, what do they mean, and then I can't say enough about the Office of Civil Rights webpage on privacy under HIPAA and its various materials that are designed to help people understand. So they have materials that are both directed at providers and materials that are directed at patients and consumers of healthcare. So both of those are very useful in explaining things, probably more useful than trying to read the regulations because those can make your head swim, unfortunately. Okay. I'm checking in on my on the questions to see if there's any. So some of the questions that we're getting are very interesting questions that I love answering. They are not necessarily get onto the HIPAA versus VAWA topic. So I want to make sure I'm staying on topic and then also inviting people, if there are other questions that are similar but not exactly about HIPAA versus VAWA that come up or have come up for you today, that you reach out and you send us an email and ask those questions so we can discuss them with you. In terms of the question about sexual assault response teams, there are excellent materials about model memorandum of understanding and practices within multidisciplinary teams that are available on tools.nnedv.org. If you have questions after looking at those materials, then you should email us and we'll happily have a discussion about it. So just to recap what we've been covering, if when you're thinking about how does VAWA, FVPSA, and HIPAA apply together or separately in your specific situation. I'm sure some of you are thinking, wait, but what if I have something really specific I want you to answer? Start from the position of, don't assume that HIPAA is the same as VAWA or the same as FVPSA. Don't assume that HIPAA is the gold standard. And then go to the actual rules. And again, you can start your research with that comparison chart that we put together for you, and ask for technical assistance or legal advice. Don't try to muddle through on these questions. If they feel hard, you're right, they are hard and they are complicated. And anything that's complicated is worth sort of getting help with so that you can get it done well. The absolute bottom line on the statutes is that it is different purposes, different assumptions, different professions, and the outcome is that there are different levels of privacy protection. So I have a question about, does having one child therapist in a non-residential community-based advocacy agency qualify as a healthcare unit when both the adult and child therapy program are under VAWA FVPSA? So the answer to that question lies in the chart, which you can open up and look at if you'd like, which is that one child therapist providing healthcare and transmitting healthcare information electronically. And if you are billing any kind of insurance company for that healthcare, then you're almost certainly transmitting the information electronically. And if those two things are true, then that therapist is probably covered by HIPAA. And it would probably make a lot of sense to seriously look at whether you want to designate as a hybrid entity so that that therapist can have their information kept separately, where the therapist follows HIPAA rules and follows VAWA rules because they're getting the VAWA money, and then the rest of your program follows VAWA rules. I have a question about, let's see, I'm sorry. I have another question. Our program is part of a mental health agency. Many of our shelter residents receive counseling from the agency, but VAWA FVPSA funds are not received by the agency but are by the shelter. Do we need to have residents sign a release? So I think what you're asking is, we have a mental health agency that does a lot of different things for people, and one of the things that the agency does is it has a shelter, and that shelter is funded by VAWA and FVPSA. So when people come into that shelter, do we need, if they want us to share their information, do we need to have them sign a written release before we share it? It looks like the answer to that would be yes, and I'm doing that lawyer thing where I'm like, I don't, without actually having a direct relationship with someone, I'm not going to, give you advice, definitely do this or definitely do that. But if you are running a shelter that is owned by a larger organization that does, frankly, anything, that shelter is really, it's a different entity, right? It's providing a different service. It's doing a different thing. And I think the smartest best practice, regardless of what the laws are, is to contain information within that shelter, because you are trying to provide safety for people who are literally fleeing for their lives. Not everyone who comes into the shelter is at risk of being murdered, but someone is. And so you want to have practices in place so that anyone who walks in there, if they are the person who is fleeing their attempted murderer, they can stay secret in that shelter and they can stay safe. And that your sort of practices contain that information rather than risking oversharing it. So think that gets at the question of, anytime somebody says, do we need to have residents sign a release, that's always my cue to say, you never need a release. You never need a release. Survivors may decide that they want you or need you to disclose information. If a survivor decides that they want or need you to disclose information, then VAWA says they need to write down a set of written instructions for you and sign them so that you know exactly how they want you to do it. And that if you don't have those written instructions, you don't actually have authority to share information for them. But it is always you doing it for the survivor. It is never us needing a release from the survivor. It is the survivor needing the program to take a specific action and giving you written instructions to do it. So I have a question, is having an electronic data management system making the agency HIPAA bound? Is this meeting electronic transmission definition? The first question is, are you providing healthcare? Are you a healthcare provider? So if you are a shelter who has no mental health counseling on site, who has no doctors who work for you and are providing medical care in your shelter, which is the case with most shelters, there's nobody providing medical care who works for the shelter and is a part of the shelter. If you are not providing health care, then HIPAA shouldn't be applying to you. And the question of using a cloud database is an entirely separate question, an important one to be looking at, and I think it has an impact on your VAWA restrictions and requirements. But the mere fact that we do something electronic doesn't make us HIPAA covered. Otherwise, every single one of us would be HIPAA covered because we're all on a webinar right now. It is you are a healthcare provider who is using electronic mechanisms to send healthcare information. So a healthcare provider who uses electronic means to share healthcare information is going to be covered by HIPAA. But if you take any one of those things out, then you're probably not covered by HIPAA. And if you think that you're on the line of being covered or not covered, then it's important to take a closer look at that question. Okay, we are almost out of time, but I just want to see if there are any more questions I can cover today. If someone has a question they didn't get covered, again, please email us. I have been told by many bosses that that I'm the kind of person who's always immediately interested in whatever is the shiny new thing. And every time you send me an email asking a question, you have just become my shiny new thing. So so I love getting questions because I like being able to help people. And I know that these things are complicated, and so it's useful to be able to really sort them out. I have somebody here has said to me that reasonable notice to the victim is not what I read in HIPAA. It says that notice must be given. I'm fairly certain, but I'm always willing to be wrong because at the end of the day, the only thing that matters is what a statute actually says. But there are sections of 45 CFR 164.512 where the doctor is allowed to make a decision that it is not in the best interest of the patient to give them notice of information. So there's that regulation 164.512 has lots and lots and lots and lots of subparts. And it's part of the reason why both in the webinar today and also in the comparison chart, I did not try to lay out every single subpart. Believe me, there's a version of the chart that looked like that, and it made both me and my colleagues at NNEDV want to cry to try to read it and use it. So I made a decision that I was going to essentially summarize some of the things that can happen or that are possible under HIPAA, but that does not mean that that it's going to work that way in every single situation. And again, if you are HIPAA covered and you're trying to determine whether or not you are required to disclose information, allowed to disclose information, or prohibited from disclosing information, go to the rules. Or go to whoever is giving you legal support to ensure that you follow the rules under HIPAA. It's extraordinarily important to do that because that's what lawyers do. Is you come to a lawyer and you say, I have a question, can I or can't I do this? The good lawyer is going to go to the rule and read it with your particular situation in mind to determine what the answer is for your situation. even if they've read that rule 100 times before. Because it can look different when there's a specific situation sitting in front of you. So I have a question, where do you go to designate as a hybrid entity? That is an excellent, very practical question that I do not know the answer to. I would start with the OCR's privacy website. There's a section in it that is for providers, and I would go there to determine and start to research what are the procedures for designating as a hybrid entity. And again, I am not telling anyone on the phone, go out tomorrow and designate as a hybrid entity. What I'm telling you is that this is a possibility that exists under the law, and that you want to take a look at it and determine whether it is the right thing to do for your organization. But I will tell you, in my experience, I almost never hear anyone talk about it. And so I wanted to make sure that people were aware that this is an option. I'm 1 minute past my time, and I pride myself on trying to be timely. I have just gotten a question about cloud-based databases and the fact that there is no such thing as a business associate under VAWA. Please, you can both look at the materials on NNEDV's website about cloud-based database, but you can also send a direct email and we can have more detailed discussions about that, because that is a very present issue. And I know that lots of technology providers out there are telling domestic and sexual violence programs, don't worry about us, you can totally share information with us, here's our standard business associate agreement that we use. And the problem with that answer, and the problem with them saying to you, don't worry, our database is HIPAA compliant, the problem with those two answers is they are not telling you that their database or use of their database complies with VAWA, probably because most of the time they've never heard of VAWA, and this is a whole new field for them to even be thinking about. And so you're going to end up educating the database providers as much as anything else about what are the laws that you're required to follow if you are a VAWA or a FVPSA grantee. All right, everyone, I've kept you 2 minutes past. I'm sure you've all packed up your backpacks and put your books away, and the bell is ringing and you're running out the door. So I hope you have a wonderful afternoon. Thank you so much for attending and for bearing with me when my chat box froze up. And absolutely, I cannot say this enough. If there's anything in this that you still have questions about, or you're trying to think about your specific situation, reach out for technical assistance and or for legal advice to local counsel. Thank you, everyone.
Yes, thank you everyone for participating in this. I'm sorry we did go just a couple minutes too late, but I don't think anybody minds about that because the chat box seems very happy. We will be sending out a follow-up with a ton of materials, including the presentation, the chart handout that Lish had referred to, several of our other handout documents, some links to where you can get templates and tools to continue this conversation. Please email us with your specific questions. We are happy to help. We will also be sending out the recording links. So as soon as that becomes available, we will send out the follow-up email with all of these resources. Thank you so much for your time today and participating in this webinar. We appreciate your time. Please email us with your questions. Thank you and have a great day.